Good morning. This is the House Judiciary Committee. It is the 23rd of January at 11 o'clock. We have several bills, four bills that we're going to hear this morning before a 2:30 hearing in conjunction with the Appropriations Committee in the Joint Hearing Room. We're going to start with House Bill 152, and Delegate Kaufman is already at the table. The other three people who I see who are listed, I think, as well, maybe not, as testifying favorably. All right, why don't you have them come on up and we'll go ahead.
Okay. I suppose some of the other people, Mr. Chair, are running late, so perhaps we could slate them into a later panel with your indulgence. Okay. Good morning, Chair Crutchfield, Chair Clippinger, Vice Chair. I just elevated my friend, just a little bit of my nerves. Good morning, Chair Clippinger, Vice Chair Bartlett, and esteemed members of the Judiciary Committee. I am Delegate Aaron Kaufman. I'm asking for a favorable report on HB 152. The Child Custody Evaluators Bill. As you may remember, I brought this bill before the committee last session, and Delegate Atterbury did so the year before. In the interim, I have been working closely with my Senate cross-file Mary Beth Carrozza, Delegate Charlotte Crutchfield, who's my subcommittee chair, and Judge Kathleen Dumais to work on the language of the rule and to establish requirements for custody evaluators that we are all amenable to. I thank all of them for their time and efforts and appreciate their input into this bill. This legislation, as you know, is critical to ensuring that persons determining custody outcomes in cases of physical, sexual and emotional abuse, domestic, physical and sexual violence, and child neglect, trauma, and parental coercion have the relevant experience. This legislation requires custody evaluators to complete 20 hours of initial training and 15 hours every 3 years after that, thus aligning the training along the same lines as the training that judges undergo. Judges rely heavily on custody on the recommendations of child custody evaluators in custody proceedings. This training is of paramount importance in order for evaluators to decide the best outcomes for the safety of the children. This bill is about putting children first. You may hear from some other advocates about the issue of parental alienation, which is entirely a separate issue and has no place in the bill. Clearly, the current system is not working, as the system has failed many families by putting parents and children in danger by requiring children to be in the presence of their abusers. I appreciate the efforts of the Maryland Judiciary and the training that they do. However, you will soon hear from advocates who believe that the system is broken, and frankly, Mr. Chair, they do not trust the judiciary or the legal establishment like the Bar Association, because the system has failed them. I feel the updated requirements of the rule are a step in the right direction, but no one has ever been able to articulate any harm to me for having it both in the rule and codified. And there's precedent for what I'm trying to do, because we passed, before I became a delegate, a judicial training bill that they opposed because they said they were doing it, and we passed it anyway. And so I hope we follow that same path. 90% of the recommendations of child custody, of the outcomes of child custody evaluators. Okay, I'll skip. Can I just finish up a couple? So what I just want to say is, please read the rest of my testimony, but this bill has bipartisan support. And so and I just want to reiterate, in my view, there's no harm in having it in both the rule and in statute. And I thank you for your consideration, and I will take any questions.
Chairman Clippinger, Vice Chairman Bartlett, Delegate Kaufman, and members of the committee. As the Child Advocacy Center for the largest county in the state, we work every day reducing emotional impact of trauma for child victims of physical and sexual abuse, neglect, witnesses to domestic violence, and other life-changing events. Almost all of the children we serve are referred to us by caseworkers, including social workers and investigators from Child Welfare Services, from the police, and increasingly court-appointed custody evaluators. While the proper licensing and credential requirements are currently in place as a rule, this bill further specifies the types of training and experience it is so important for these workers and evaluators to have in determining what is truly best for the child victims. Studies continue to show that how childhood trauma, if not addressed, has a negative effect not only on the victim's ability to lead normal, healthy lives into adulthood, but also a significant long-term negative economic impact on the children, the counties, and the states in which they live. This bill helps specify the range of trauma-inducing situations evaluators are going to be confronted with every day. In the last year, we at the Treehouse have conducted almost 24 training sessions on various aspects of child trauma for the Montgomery County Police, for the teachers and counselors in the school district, for child welfare services supervisors and caseworkers, and coincidentally, yesterday, all of the court-appointed custody evaluators spent 2 hours at our offices as well. It is our hope that this legislation may help ensure such trainings become more commonplace in other jurisdictions throughout the state of Maryland. It is for these reasons and in the best interest of the children of Maryland that the Treehouse Child Advocacy Center wholeheartedly supports this legislation. Thank you.
If we could have, we'll hear from Tina Swithin for 2 minutes, please.
Good morning. I am here to voice my support for Maryland HB 152. My name is Tina Swithin. For the past 13 years, I have been advocating for family court reform across the country, and my organization has a chapter in Maryland, which I oversee and manage. And I could take any family court case in the state of Maryland and put it in front of 5 different evaluators. I guarantee you we will have 5 wildly different outcomes based on the evaluators' licensing, training, expertise, experience, and biases. This, coupled with the fact that family court has no checks and balances, no regulation, no oversight, it's a crisis. It is terrifying, and even more so given that we are discussing the most vulnerable members of our society, our children. Our children deserve evaluators who are trained to make recommendations that are truly in their best interest. We have a family court system that is arguably one of the most important branches of our judicial system, because it's cradling children's lives in its hands. And every week I hear stories of horrific abuse and of children being murdered. And the only thing worse than hearing these stories is knowing that in most of these cases, these tragic outcomes were preventable. It seems fundamental that any evaluator responsible for decisions impacting a child's life should have training in domestic abuse, child neglect, child abuse, trauma. That should be basic and essential requirement for all professionals working in family court. And Maryland has an opportunity right now to lead the nation in passing legislation that prioritizes child safety above all else. There's still a tremendous amount of work to do, but this is a huge step in the right direction. HB 152 is common sense. Protecting children is common sense. And it's time we infuse common sense into the family court system. Thank you
very much. Thank you. All right. Paul Griffin, you're supposed to be, you're listed as favorable here, and that's, I'm trying to go off the list here a little bit. Mr. Griffin, please.
Yes, sir.
2 minutes.
Thank you. Good afternoon, good morning, Mr. Chairman and members of the committee. Thank you for having me. My name is Paul Griffin. I'm the legal director of Child Justice. Child Justice litigates free of charge child custody cases in Maryland involving domestic violence or child abuse. We are one of the few organizations in Maryland that solely focuses on this very narrow issue. Now, I don't believe there's much room for debate anymore that custody evaluators in Maryland need to be properly trained. Currently, they are not properly trained, and that applies to custody evaluators we see throughout the state, and no county is an exception. This is so because under the current language of the rule, excuse me, sorry, I grabbed the wrong one here. Under the current language of the rule, judges have the ability to waive all training requirements. Now, I'm pleased to report that the Judiciary is now in the process of eliminating that waiver, and that training will be required of all custody evaluators. But currently, under the current rule, it is not required. So really where we're at now, the current debate is whether the training requirements should be mandated by the Judiciary's rules of civil procedure or by statute. In prior years, opponents of going the statutory route have complained that the bill was far too detailed and the granular details should be left to the rulemaking process. So this year's bill has been greatly pared down such that it basically tracks the language from the rule. Therefore, there should be little room for complaint in that regard. But legislation is still necessary if Maryland hopes to receive federal funding for this training. Under the federal law known as Cadence Law, the federal government has authorized funding to the states to conduct this training if certain provisions are mandated by law. Now, our understanding is that law means statute to the federal government. It does not mean a mere state rule. Our further understanding is that Maryland's share of that funding is almost $300,000. Now, Maryland won't qualify for funding yet, even if this bill is passed. There's other requirements, but those are for another day and other legislation. But this bill is still necessary, even if not sufficient, to get that funding. It won't qualify at all for funding if there isn't legislation requiring certain qualifications for custody evaluators, such as set forth in this bill. So simply put, given the current atmosphere of austerity and pending budget cuts, we ask the legislature not to cut Maryland off from that source of funding, and we ask that this committee favorably report HB 152. Thank you, sir.
Thank you. Who are you? So we'll put you on the next panel. So you're going to be on the next panel. All right, right now we'll take questions for this panel. And we'll start with the vice chair, and then I see Delegate Cardin.
Thank you, Mr. Chair, and thank you, Delegate Kaufman. You mentioned that you worked with, you did a lot of work over the interim. Can you tell us any specific changes that might have been made from when it was presented the other two times?
Well, I think imitation is the greatest form of flattery, Madam Vice Chair. And so what they basically took is the bill that Delegate Atterbury introduced and then passed to me, and put a lot of what I had in the bill in the rule. And my own thinking is, and I appreciate that, and Judge Dumais is a friend of mine, and thank you also to Subcommittee Chair Crutchfield. But I believe, so the big dispute left between us is that I believe that it should be in statute, because I'm always skeptical when entities say they can police themselves.
Gotcha. Thank you very much.
Delegate Cardin.
Thank you, Delegate Kaufman, for bringing this very poignant piece of legislation, and for your organization and putting together very esteemed panels. Really appreciate it. I'm trying to do what Delegate Kaufman often does when he asks a question. The Judiciary, I'm going to give you an opportunity to preempt, I don't know if they're testifying in opposition or not, but the Judiciary did put in written testimony. And they mentioned, very similar to how you mentioned it, that they have adopted a rule that is, for all intents and purposes, overlaps what your legislation does. In fact, what they say is that although there's significant overlap, there is one differentiation which would impact in the entire state, 2 county employees in Anne Arundel County, it looks like, in the entire state, because of the way that the rule was adopted. It also says, and that's the only difference that it would make. It also says that the Supreme Court's authority to adopt rules that, quote, shall have the force of law until rescinded. Similar to legislation until we decide that we don't want that legislation and we change the law. So why, it seems like you guys are like really, really close. And your concern, I guess, is that you don't think that the courts can do what they say they're going to do?
Well, I mean, and if it's okay with you, Mr. Chair, I'm partially going to defer to Mr. Griffin, but I would just say, and I have great respect for the judiciary, but I would just say that they say all that, Delegate Cardin, but I believe that the judiciary is a turf-conscious entity, and they don't like it when they feel we are encroaching on what they perceive as their turf. So that's what I think this is really rooted in. But Delegate Paul has some more specifics.
Thank you. He's promoted me now to delegate. Sure, thank you. Regarding the force of law, we understand that's Maryland's interpretation internally. We're not confident. The one who makes a decision on whether it's sufficient to get funding is the Attorney General of the United States. And they're going to look to federal law. And they have intentionally put the word law in here. And we don't think Maryland's interpretation internally that has the force of law may be correct, but we don't think something even having the force of law is going to be considered a law, a statute. And when going with statutory construction that we all learned in law school, you look at the entire bill, or the entire federal bill, it uses the word law when it talks about the qualifications, which was covered by the current bill that we're proposing. But it uses words like policy or uniform standards when it talks about some of the specifics, which we can defer to the judiciary to create through its rulemaking process or other processes, because the law does not require them to have that as a law, as a statute. So we think that the Attorney General is going to key off of those distinctions, that even the bill recognizes a difference between a rulemaking process, even though it doesn't use that phrase, and policies versus a law or a statute. So we don't agree that the interpretation under the federal law is in line with Maryland's interpretation of the effect of a rule.
Fair enough.
And regarding the two employees, I'm sorry.
No, I'm going to say we can banter back and forth, but I understand your point.
Sure.
Maybe we can discuss it a little further.
Sure, happy to. I don't know about the 2 employees in Anne Arundel County. I'd have to know the specifics of it, but if there's only 2 employees in the entire state, I don't see why they can't be brought up to qualification or.
I think that was their point.
Yeah.
I think that was their point. Yeah.
Thank you very much, Mr. Chair, and thank you, Delegate Kaufman, for all the hard work you put in over the interim in working with the judiciary and others to ensure you had a really good, solid bill. So one of the things I know that you also did during that time was to definitely try to align the judiciary's rules with your bill. And would you be agreeable to an amendment that would include those 2 Anne Arundel County evaluators?
Yes, yes, Madam Chair, whatever can get me 15 votes, I'm amenable to.
Thank you very much.
Okay. Some would argue that a turf-conscious entity might also be a co-equal branch of government. Wouldn't you agree?
Well, yes, but what I will
Thank
also...
you very much. Are there other questions for this panel? Thank you very much. We'll go on to the next panel. Yakov Eichenbaum, Leslie Margolis, virtually Rael LaPenta, Lori Krawcheck. So we'll have a different person coming on virtually. Everybody's going to get 2 minutes, and we'll take some time. Whoever.
Good morning, Mr. Chair, members of the committee. My name is Leslie Seid-Margolis. I am a managing attorney and policy counsel at Disability Rights Maryland, which is the protection and advocacy organization for the state. Our mission is to further the civil rights of people with disabilities. We appreciate that House Bill 152 and its corollary have been introduced. At the time that the Americans with Disabilities Act was passed, Congress found that there were discriminatory policies and practices affecting people with disabilities in every aspect of their lives, including having custody of their children. About 11 years ago, in 2014, the Maryland Commission on Child Custody Decision-Making issued a report. It included the report of the Subcommittee on Disability Bias and Neutral Language Subcommittee. That subcommittee made a number of recommendations, including recommendations about training. We know that decisions about child custody are often made based on assumptions about disability rather than on evidence. So we are proposing an amendment that would require that child custody evaluators receive training in maintaining neutrality by recognizing and addressing personal attitudes, implicit bias, and assumptions that may compromise neutrality, that they also receive training about the supports and services available to children and adults with disabilities, including accommodations for parenting, and training about the use of objective criteria when making custody determinations that, or recommendations that involve a parent with a disability. I hope that you will consider this, and I am happy to answer any questions. Thank you.
Thank you, Mr. Chair, members of the committee. My name is Yaakov Eichenbaum, and I represent the Maryland chapter of Parental Alienation Intervention. The Association of Family Conciliation Courts in its custody evaluator guidelines requires evaluators to be trained in specialty areas such as domestic violence, false allegations, and alienating behaviors. If an evaluator lacks expertise in any of these areas, the evaluator is ethically obligated to decline the evaluation. House Bill 152 omits alienating behaviors. This omission not only fails Maryland's children, but it makes evaluations subject to dismissal due to ethical violations. Now, Delegate Kaufman has insisted that parental alienation should be in a separate bill. Now, this logic is akin to mandating training for violence that's committed with the right hand while ignoring violence which is committed with the left hand. This is an illogical and counterproductive approach. Now, the suggestion of separate bills was raised at last year's hearing and explained at that time that the dynamics of custody cases are so interconnected that a forensic decision cannot be made in a vacuum. Training has to encompass all the relevant aspects in order that informed decisions can be made in these evaluations. We're also concerned that the domestic violence community, which has openly expressed their intent to totally eliminate alienation from the family court system, that they're going to try to influence this training. We therefore urge the committee to amend this bill by explicitly including training on parent-child contact problems. This simple addition will ensure that evaluators are prepared to navigate the full spectrum of issues. Further details of our amendment and the reasons are in our written testimony. I thank you for your time and consideration of this critical amendment, and I'm happy to answer any questions about the amendment or parental alienation.
Thank you for having me. I support House Bill 152 with one amendment, and that is adding parent-child contact problems. It's almost a common sense addition. First of all, just because people are trained and they have licensure does not mean that they are trained in all dynamics of coercive control, of alienation, of covert types of abuse. The second two reasons really have to just reiterate that Maryland court's own policies that say that parent-child contact failure, it's mentioned several times in the court's training documents, should be included. Why it is not here, I don't know, and I don't care to speculate. I think a lot of my testimony would mirror what Yaakov said here, that we are in agreement that all evaluators need more training and a more standardized form of training. So I support an amendment, this bill with an amendment. Thank you.
Ms. LaPenta, please, for 2 minutes.
Hi, respected legislators, and I appreciate the people that have testified so far. My name is Rayel LaPenta, and I'm here as a representative of Mothers Against Child Abuse, which is a national organization advocating for victims of child abuse and protecting children from all forms of maltreatment. I did respectfully submit testimony, written testimony with ample resources for our position of support with amendments. This legislator is obviously critical, as everyone said, to address concerns around child custody. The piece that we feel like is missing is the psychological maltreatment. If you look at Maryland's child trend data, I don't know another state that has less than 0 ever psychological maltreatment findings. To our organization, it seems like maybe no one's looking for it, because it's the national average is 7% they find, which is low. So if Maryland is finding none, this would be an important area to explore and to add specifically. As well as the AFC training already included things like parent-child contact problems, and psychological maltreatment is recommended by Maryland on their own page. So our recommendation is to expand the assessment to include parent-child contact problems, specifically including things like psychological maltreatment, adopt evidence-based models like the AFCC has, and mandate the specific training that would include an additional specialized assessment if there was parent-child contact problems, as the Maryland courts already has set up. After a child custody, it would be a specialized piece. So I appreciate your time and letting me share. Thank you.
All right, are there questions for this panel? Delegate Eric Han.
Thank you, Mr. Chair, and thank you guys all for coming in and sharing. I was just reading through the bill, and it looks like on the last page, yeah, where it goes through the list of things, starting at line 13, it does say in here, family conflict and dynamics. I feel like maybe parent-child contact issues would definitely, it looks like it would fall under family conflict and dynamics.
Okay. I agree with you, Delegate, that it's certainly an argument that can be made that it would fit in there, but I think that since there are opponents of alienation, I think that they would try to make a case that that would not be included in there. And therefore, I think that's why it's vital to have it specifically mentioned in it.
So I think you probably heard the testimony. They're creating this just like to turn the rule into a law, just essentially so that we're, accessible to federal funding. So changing it, of course, could defeat the purpose of getting the federal funding if we changed it in a way that made it in conflict with the rules of the Fed. So is it have you gone to the Judiciary and asked them about this issue? Do you have any information from them about it?
We did try talking to the Judiciary, but unfortunately, a delegate has a lot more of an in to actually talk to people in the Judiciary, and as a private citizen, it's impossible to get past the gatekeepers to actually talk to them. If you could arrange for a meeting for me, I would be very happy to do that.
Yeah.
As far as the federal funding, my understanding is that even the states that have passed the full package of Caden's law, no money has been allocated to those states yet.
Oh, it's new. What? Is it because it's new? Is it a new?
No, I think there's things going on, and we've been in touch with members of Congress. And they're working on tweaking this bill. It's not so simple that any state is ever going to see this money.
Okay. I know we talked about the funding has to be verbatim, too, when we talk to the VAWA people. So even if it's not exactly verbatim, then the chances of you getting the money already is less than the money that the VAWA people that shared it with us said there was less money than they thought. that was even going to go out if you did it verbatim, but you could add that piece to the training. So just like I know I'm a special ed teacher, so disabilities is a very misunderstood thing, as that previous witness was saying. Disability is a huge category and it could be very broad. And if you don't have that very specialized training, and in my written testimony, I have so much research in there about all the damage that could be done when you misdiagnose those kind of things with psychological treatment and parent-child contact problems. So I feel like it's a specialized area that needs to definitely be addressed.
Okay, well, I appreciate you guys coming in today. Thank you.
Thank you. Just a note for those of you who are on virtually, once your panel is over, that's it. We don't go back to previous panels to give you further opportunities for bites at the apple, so I'm sorry. Are there further questions for this panel? Delegate Conaway.
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. The last person to testify spoke about psychological maltreatment, and in reference to that, it was said something about it being common sense. And I recently had an experience where a term was used, incorrect item, which I was told should be common sense, but because there's no definition for it, it's not common sense in what we do. So is there a term definition for psychological maltreatment, and where do we find it?
There is. I can look it up real fast, or I could tell you in my written document. Yeah, in my written testimony, I put the child trends. It's from the Child Welfare Bureau nationally, and so I have that link in my testimony.
Thank you so very much.
Thank you. And that was a good point. It's not, maybe it's not common knowledge. More of a reason to.
The definition is also in the DSM-5. It has a glossary in the back where it actually has an exact definition for all these terms.
Thank you so very much.
All right. Seeing no further questions for this panel, we thank you all very much. There was one person signed up to testify in opposition to the bill, Michelle Smith. Please.
Mr. Chair, Madam Vice Chair, I'm Michelle Smith. I'm here on behalf of the Maryland State Bar Association Family Law Section Council. Hello, everyone. It's my first time testifying this year. It's nice to see you all. I'm going to really take my time to address some of the comments that were made and bring some clarity from our perspective as to why this bill is just not necessary. We don't oppose it because we hate the idea. We understand that the bill's most important and critical elements have been adopted into the amendments to the rule. And I know the judiciary attached that rule to their testimony. I've also referred to it. It is available online. So one of my first comments is the rules process is very open to the public. That's a way you can get into the judiciary. That's the way you can get your comments made as to amendments to the rule. The rule does make the training mandatory. It's on page 6 of the rule. That has already been passed on January 10th. Our concern is that if we have a statute that is passed by this body after the rule has been amended, the statute is going to be the new law. And that's just simply, you'll see it in my testimony. I don't want to read to you because I know you all can read very well. But the rules constitutionally have the effect of law. I also don't want to wade into the pool with regard to who wants funding and why they want specific things in a statute so that they can get funding, because the point here is that the custody evaluator should be trained according to the guidelines established by the courts. That is in the statute and the rule. So any other private agencies that just want money from this statute, I don't have any comment about. I would just refer you to my testimony. We urge an unfavorable report.
Thank you for being here. It's good to see you again.
Good to see you too.
I hear you on the funding piece. I think, and you can tell me if this is true. I mean, these organizations are helping the people that can't actually hire great attorneys like you, they can't. You know, I'm in a custody case right now, and I've spent $100,000, and it's unsettled. So there's just a lot of people who can't do that. Very similar situation to what's been described here. So do you think it would be worth it to try to match a rule so that, you know, the women who are, many times women who are struggling to get representation would be able to have access to it?
Oh, Delegate, I think that's a separate issue. My understanding of the testimony that was given is that they want a statute so that they can get funding for training for the evaluators, not for representing clients. But perhaps I'm wrong about that.
I'm not sure. They didn't specify in their testimony,
Yeah.
but I think that's what these organizations typically do, is they represent women who are unable to afford it.
And I'm absolutely in favor of that.
Okay, thank you.
Thank you, Mr. Chair. Thank you very much for testifying. So notwithstanding the amazing intentions of Delegate Kaufman, just want to clarify, since the Judiciary is not here to testify, but the bar is, so maybe from your perspective from the bar. So when a rule is in effect and there's a requirement, what does the Judiciary need to do to make sure that that requirement is upheld?
Can you state your question another way? I'm not clear.
There's a rule that says that there has to be 20 hours of training for these evaluators. What does the Judiciary do to make sure that happens? What kind of, what are they required to do?
Oh, so they have very specific guidelines that they implement and a training protocol. And in fact, one of the lady, I'm sorry, I don't remember her name, from the Disabilities Organization, has worked in tandem with Judge Dumais and some of the other Judiciary individuals who are on that rule committee. And I think for the training, they've already included the training that she was discussing. So they keep that training up to date, and they implement the training, they provide the training, and they must follow the rule with regard to those guidelines.
If it is learned by a judge that there's somebody out there doing this work that has not complied with the rule, what happens?
The evaluator?
Yes.
Okay, so there are evaluators that do their work as part of the county employment. And I just want to say that the two evaluators in Anne Arundel County, Ms. Laird and Ms. Harger, I have worked with for a very long time, and it would be an extreme disservice to our county to lose those two employees. So if the statute's going to pass, please, Delegate Hoffman, please make that amendment to save their jobs. If those county employees do not meet the qualifications, they must not continue to do the work. Okay? Then there are private evaluators. If they don't meet the qualifications, they should not be doing the work. And I believe that the way this would get hashed out, which is very interesting, is that if, now that we have the amended rule, and I have seen this happen before, if an evaluator testifies in a case as an expert or provides a written opinion as an expert, and they do not meet the qualification, it is incumbent upon the parent's attorney or the parent who is not in favor of their recommendation or their work, thinks their work is not complete or the requirements have not been met, to alert the judge, file whatever motion is necessary to have that report stricken, to have the testimony stricken or not allowed in the first place, not admissible.
So if it becomes apparent that this person did not meet the qualifications, a judge is permitted to strike all of their recommendations. So the rule, for in effect, is requiring this sort of bare minimum type of training to make sure it's done, or they put in jeopardy the reputation and their employment.
Exactly. Okay. I think it would be borne out on two avenues. One would be the Judiciary in that particular case or cases that the evaluator is working on would make findings And then the other avenue would be the person's employment would be in jeopardy, or their accreditation through the courts as an evaluator.
Thank you. Thank you. Thank you, Mr. Chair.
Further questions? None. Seeing no further questions. I'm sorry? Congolo? No, I'm sorry, Delegate Congolo, sorry.
Thank you, Mr. Chair. So I just want to make sure that I'm clear. So you are advocating for, you mentioned 2 Anne Arundel County court assessors or evaluators, and these are people that are well experienced,
Yes.
but they do not meet the requirements in terms of level of education and training.
Exactly correct.
Okay.
They were previously grandfathered in the last statute. They've been practicing doing this work and good work for more than 14 years.
Right, and I can appreciate the years of experience, but I do understand, well, full disclosure, I am a licensed clinical social worker, okay? This is not my area of expertise. You know, we have a working knowledge of trauma, we have a working knowledge of a variety of mental health or, you know, family issues, but I can appreciate Delegate Kaufman's, recommendation to have more specialized training, more advanced training, because, you know, we're practicing within our scope of practice, but if you're not an expert, then you're not really going to be able to do the thorough job needed. So I just wanted to just put that out there. I'm not sure if you or others are aware that this definitely goes beyond just having a working knowledge, and having that specialized training does make a huge difference in, you know, the way that we do our jobs in those specific areas.
I do agree, and the rule has captured all of the components of Delegate Hoffman's bill with regard to that. It mirrors it. So I think it's a huge success, and it's a great way to sort of put this issue to bed.
Mm-hmm. Okay, thank you.
All right, now, are there any other questions? Seeing none, thank you very much. That concludes the testimony on House Bill 152. We're going now to House Bill 89 and Delegate Embry, please. Delegate Embry, Jennifer Bevan-Dangle, Joy Wilson, Catherine Flory. We could have all of you come up to the extent that you're in the room. All right. Delegate for 3 minutes, everybody else for 2. We will give people a chance to leave the room quietly and quickly. All right, please, Delegate Embry for 3 minutes.
Thank you, Mr. Chair. Thank you, Madam Vice Chair, and all of my wonderful colleagues. This is a bill you will recognize. It is identical to the bill that we passed last year. The Senate also passed it. It almost made it over the finish line, just a matter of timing. So this is the same bill, and it does 2 things. One is that it prevents the merger. This applies in animal cruelty, animal abuse cases. If they are charged, if there are separate animals harmed and the charges are separate based on the animal, this clarifies that those counts cannot merge automatically, and also for purposes of the Sentencing Commission, clarifies that it is our intention as a legislature that these animals are considered victims for purposes of the sentencing guidelines. It does not mandate any certain sentence. The counts can be run concurrently. It just requires the judge to consider each animal as a separate victim. There is no opposition. This is supported by law enforcement. We added an amendment last year to make sure that this had no impact on hunting and fishing and other sportsman activities. So we encourage your support again. And because you passed it last year, I will not use all my time and will turn over to my witnesses. Thank you.
Good afternoon, Chairman Clippinger and Vice Chair Bartlett and all members of the committee. My name is Katie Flory. I am the treasurer of the PAWS organization as well as the Community Care and Advocacy Director with the Maryland SPCA. Again, I do not want to kind of continue to go over what's in our written testimony, but I do hope we provide a favorable report for this bill. And I just want to tell you one very quick story which kind of goes to the heart of it. We are not an animal control organization, but we bring in about 3,000 animals a year. About 2 weeks ago, we brought in a dog. Her teeth had been ripped out of her mouth. She had several wounds across her body. She is about 20 pounds and should be about 60. She is the sweetest, happiest dog you will ever meet. And what keeps me up at night is thinking about the other animals that may be in the home where she came from, and that if we are able to prosecute, that we would only be able to prosecute for one. We ask that every animal be considered when it comes to sentencing, and that we hold people accountable for the crimes that they are committing against animals. I really hope for a favorable report, and thank you so much for your time.
Good afternoon, Chairman. Thank you for everybody listening for this. As a certified animal control officer in the state of Maryland, I strongly support House Bill 89, crimes relating to animals. My responsibility to the citizens and the animals of this state is to ensure that in cases with large numbers of animals, each one is recognized as an individual victim. On multiple occasions, I have encountered animal hoarding and or animal fighting cases that did involve large numbers of animals. The perpetrators in these cases would inflict harm, suffering, abuse, and or aggravated cruelty to every animal in their care or custody. One case of note involved a starving of 20 horses, with one being deceased upon our arrival. Another case involved 11 dogs being kept secluded in the woods in order to hide the training and maintenance of game-fighting dogs. In each of these cases, a charge was filed for every animal in circuit court. If House Bill 89 does not pass, cases such as these would have the sentencing merged, meaning that someone could abuse, harm, neglect, or cruelly treat one animal or 20 animals and be sentenced the same. Please provide a favorable report for House Bill 89.
Good afternoon, Mr. Chairman, Vice Chairman, members of the committee. My name is Jennifer Bevan Dangle. I'm the lobbyist for the Humane Society of the United States. I simply want to thank you all for your hard work on this bill last year. The sponsor and this committee did a lot of work on the amendments, trying to make sure that the bill is as fine-tuned as possible. We don't want to change the status of animals under the law, which is why there is some of this language in here to make sure that this is only for the purpose of looking at the stacking rule. I also do want to stress, as the sponsor mentioned, that the sentences can still run concurrently. This is just about making sure that every animal has their sort of day in court. And the most important thing our sponsor forgot to mention, the bill has no fiscal note. So with that, I urge a favorable report.
Mr. Chairman, thank you, panel, for coming in to testify. On the last note that the sentences can run concurrently, I was wondering from the person who testified about the animal who had the teeth taken out, what is the potential penalty for that?
I think that's really going to depend on what comes from the investigation. This is something that has not gone through investigation yet. I wanted to provide the panel with an example of what we are seeing and why this is important, so I can't necessarily answer that until
In general, what is the potential penalty for animal abuse?
The aggravated felony is 10 years. So I don't know whether this will be charged as that.
So therefore, you're saying in a case where there's 20 horses, if the sentence doesn't run concurrently, you could get 200 years?
If they were all convicted, if a person was convicted for aggravated animal cruelty per victim.
Yeah, thank you, Delegate. Thank you, Delegate. Have a good day.
Anyone else? All right, seeing none, thank you very much. That concludes the testimony on House Bill 89. Go to Delegate Simpson now. House Bill 241, Michelle Smith, Laurie Ruth, Brett Engler, please come forward to the table. And we'll hear from Delegate Simpson for 3 minutes, everybody else for 2. Delegate Simpson.
All right, we're not going to take 3 minutes because we passed this last year. This is an enabling legislation. It allows for the communication, for them to be able to admit this in court. It passed last year, went across the street, didn't do its thing. I'm going to let them explain. It has no fiscal note. Like I said, it's just enabling, doesn't require someone, to testify and provide that information, but it allows them to, so that they can protect themselves. And I think any piece of legislation that, says that, a woman is competent, I like it.
Hello, Chairman Clippinger and members of the committee. My name is Brett Engler. I'm a prosecutor with Frederick County. I'm the chief of the Domestic Violence Unit. I'm here on behalf of the Maryland States Attorneys Association and the Domestic Violence Coordinating Council in Frederick County, of which I chair as well. We are one of the only states, and thank goodness for my intern, I put forward the 50-state survey in my written testimony, but we are one of the only states that does not have an exception for the marital communications privilege for crimes committed against the spouse. And this issue that we don't have this exception has gone through the judiciary in the State versus Ramirez case that I cite in my written testimony. In the court in that case, it was a marital sex offense case. The victim, who was the wife, testified about what happened to her, and she shared and wanted to share an apology that her husband had given to her, and that was a critical piece of evidence, as in my cases often they are. And the husband, was able to keep the wife from testifying to that based on the marital communications privilege, because both spouses hold that privilege. So under our current law, it says that this one spouse is incompetent to share items such as that over the objection of the other spouse, and who would consent to something like that coming in their criminal trial. The case was reversed and remanded, his conviction was reversed, and it's an injustice to keep those apologies, taunts, admissions, something relevant from a judge and jury in domestic violence, marital rape cases. The reality of marital violence needs to be understood by the legislature and the judiciary. We see it every day, unfortunately, in my practice.
Good afternoon, Mr.
Can you move a little closer to him? Can you bring him a little closer?
What do I push?
No, it's red. You're good. You're good. It wasn't red.
Thank you. Good afternoon, Mr. Chair, Madam Vice Chair, members of the committee. My name is Lori Ruth. I'm the Public Policy Director at the Maryland Network Against Domestic Violence. We represent all of the domestic violence service providers in the 24 jurisdictions in Maryland. And I'm here today in support of House Bill 241. I want to thank Delegate Simpson. As she said, it passed out of here last year. I don't think that this side of the street is necessarily the problem. I just want to emphasize that this bill does allow autonomy to the victim, which is one of the network's priority goals, is to allow victim autonomy so they don't have to testify. But certainly it seems extremely unjust for a perpetrator of abuse to then be able to say, and you're not allowed to say anything about it when I called you up and apologized. If you're familiar with the cycle of violence, the circle, part of it is the honeymoon phase and the makeup phase. And you will see often perpetrators of domestic violence then apologize, send flowers, send a note, shower them with affection. And so any evidence of that is really an admission of guilt that should be allowed to come in. The testimony last year said that only 5 states, including Maryland, don't have it. I don't know, Ms. Engler, if that's changed, but I watched the video last year. And so for those reasons, we urge a favorable report. Thank you.
Mr. Chair, Ms. Vice Chair, members of the committee, I'm Michelle Smith here on the Maryland State, on behalf of the Maryland State Bar Association Family Law Section Committee. Me too. We agree with everything that was just said, and I would like to just indicate that when I testified across the street about this bill, there was some questions from the chair that were very interesting about public policy matters throughout our legislative history regarding the marital communications privilege. If you have questions about that, I'll refer you to the case I referred him to. It's Brown v. State, 359 Maryland 180 in the year 2000. It's time for us to put this ability for abusers to keep their victims silent to bed. It is really a public policy matter. The victim should have the ability, whether she's a woman or a man, to decide whether to reveal the communication from her abuser where he's admitted his wrongdoing. The idea that they are of one body and that she can't testify against him or he can't testify against her is no longer something that our society holds as valuable in that instance where there is physical violence. All the other marital communications are still intact as privileged. Thank you. We urge a favorable report to House Bill 241.
Questions, the Vice Chair.
Thank you, Mr. Chair. My first question is to Ms. Engler. Would the state's attorney office still be able to ask the victim questions about, like, maybe hospital stay and things like that? Would that spouse be able to answer those types of questions?
Yes, so there are two different privileges. There's the privilege to testify about what happened, and that would be the testimonial privilege. So in Maryland, it's a separate statute, but our law is in a domestic assault case, a spouse could refuse to testify on basis of the privilege one time. If the assault would happen in the future, she or he could be compelled by the state. So that's different. What happened to you? The victim holds that privilege. She or he can choose to testify as to what happened. What this privilege does in the law is there's a separate communications privilege which says you can testify about what happened, but you may not, over my objection as the spouse, testify as to what I said to you, which in the reality of marital violence, it happens in the home. There's not a lot of witnesses. Sometimes, and often in my cases, especially in marital rapes, there's often a delayed report. So you may not have an overwhelming, robust police investigation. Some evidence may have been lost. So that honeymoon phase where there was an apology, there was some type of admission to the wife, and then, of course, something happened, perhaps violence reoccurred, she decides to report, that piece of evidence becomes more and more critical. And to not be able to get that in when the wife is seeking divorce, wants to proceed with these charges, that piece of evidence not coming in, and the abuser perhaps taking the stand and saying, this didn't happen, this was consensual, that piece of evidence is critical, and the communications privilege, not the testimonial privilege, is what's keeping that out.
I understand. So my second question is to you as well, and that is with respect to the language in the bill that says during criminal action.
Yes.
That expands as well to not just physical abuse. Couldn't that actually, in fact, expand to psychological abuse or emotional abuse or any other type of abuse?
I think if that level of abuse is criminalized, and emotional abuse in and of itself is not currently criminalized, but let's say stalking, perhaps a harassment, if they're in those types of crimes, yes. So it would be any criminal action against a spouse. Not every crime that you can commit on another person would be relevant to a spouse, like property crime, certain things are shared. But in terms of assaultive conduct, rape, assault, stalking, those things, yes, I agree. It would be any crime.
Okay, thank you.
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. I believe I voted for this, but I just want to be clear on a few things. One of you spoke about the average delay of time to report this. Do you have a statistic on what's the average delay? A month or 2 months after the occurrence?
I think it depends on the cycle of violence that's innate in that particular relationship.
I didn't know if you had statistics, if you talk to different people. And for example, the other day we dealt with felony murder, and only 1% of the people we were told understand or have been notified about what felony murder is. So in reference to this marital sexual abuse and or rape, I was wondering, when is that taught? How does a person know that?
There's no statute of limitations. Is that what you're asking?
No, I'm asking you, how does the average prudent person know that no means no, that they cannot abuse or take advantage of their spouse?
Well, Delegate, I think this is one of these things that it really depends on the situation. From a victim standpoint, I would say it depends on when they find that ability to become safe. And for some, that can be many, many years. I mean, they could be married for 20 or 30 years, and for others, it could be, and it's been occurring over and over again. And for others, they may find that window, and they may have good individuals, that can help them get to safety, or programs that can get them to safety.
I think you misunderstood my question. My question is, when
you're
is this
asking
taught in
statistically
general? When is this? I'd have already passed that. When is this taught? When do people understand that no means no, even when it's your spouse.
Well, thanks to this committee and to this body, we're passing those laws that say you have to have consent. And with the laws that we are passing comes education.
Yes, okay. And I wanted to be clear, I didn't quite understand the comment about now the two that are married are not one body when it comes to this. And I believe that you spoke on that. Can you make that a little clearer for me, please, and for the people that are listening?
Sure. This would, so the reason for the marital privilege is a very old, and that case that I referred you to has a nice explanation of it, concept that when you marry, the two spouses become one body.
Yes.
So therefore, one spouse cannot testify against the other because it would be as though you were testifying against yourself. So this bill carves out a small exception to that to say, if you abuse your spouse, then the spouse has the ability to testify about that communication that you indicated that you might have made after the abuse or in the same time frame as the abuse, because it's against public policy.
Yes.
They're no longer one person. When you abuse yourself, you know, when you abuse your spouse, you're abusing yourself. And so it just doesn't make good public policy to say that communication is privileged.
I'm in full agreement with you, and I just want the general public to know what's going on and what they are supposed to do and what they're not supposed to do. I thank you very much, and thank you for the bill again.
You're welcome.
Further questions? All right, seeing none, thank you all very much. That concludes the testimony on House Bill 241. Last bill is House Bill 236, which I think we've heard before. We have, and we're going to hear from Delegate Valentine. And virtually is Hannah Leatherman. Okay, we'll bring up Hannah Leatherman and have her ready to go. Delegate Valentine will get 3 minutes. Ms. Leatherman will get 2. Delegate, when you are ready, go ahead.
Thank you and good afternoon, Chair Clippinger, Vice Chair Bartlett, and members of this committee. For the record, Delegate William Valentine, District 2A, representing both Washington and Frederick counties. I'm before you today to present House Bill 236, Peace Orders, Intentional Visual Surveillance. This, again, is a reintroduction of legislation I presented to this committee last year, specifically House Bill 911. For members who may not be familiar or may not remember my testimony from last year, I will provide a brief background. Peace orders came into existence in this state approximately 25 years ago, and these orders are distinctly separate from protective orders, as they apply to situations that are not domestic related, and as such may be acquaintance or, in my particular circumstance, neighbors. As members review the bill, they will see various alleged acts listed on page 2 under section 3-1503 in which an individual can currently petition the court and seek relief. These range from trespassing, assaults, malicious destructions of property, and other statutes involving visual surveillance. This bill adds intentional visual surveillance to areas of an individual's residence where they have a reasonable expectation of privacy to the list of acts for which an individual may seek relief by obtaining a peace order. I recognize that a large percentage of homeowners utilize security cameras, and this bill is not intended to prevent those circumstances or those who wish to do so. It does not create a new crime. It does not impose a new penalty. This bill simply allows judicial officers in the courts to decide if the circumstances and evidence-based that is presented justify the issuance of a peace order. My office has uploaded a packet of photographs on all of your House floor systems so that you can review the circumstances in which I'm talking about today. The legislative intent behind this bill is for an individual to be able to petition the court and present evidence to a judicial officer when he or she believes someone has initiated intentional visual surveillance to a level beyond routine home security and infringed upon their reasonable expectation of privacy. During last year's legislative process, concerns were brought by the Maryland Judiciary to myself they based on two concerns: the broadness of the wording of visual surveillance and the relief that individuals are entitled to under the existing peace order statute. Arguably, that judges did not have the authority to order the removal or readjustment of a camera in these circumstances. During the interim, both myself and Senator Quarterman's office worked with the Maryland Judiciary to address these concerns, made recommending corrections from last year's proposed legislation, and I believe that this proposed bill reflects that work. I respectfully request a favorable report on House Bill 236 and am available for any questions.
Ms. Leatherman, please, for 2 minutes.
My name is Hannah, and thank you for allowing me to speak with you today. My family is also in favor of House Bill 236 going into law because we've been dealing with a neighbor who has had video surveillance on our property now for over 2 years with multiple cameras. After talking to police and a lawyer, we have found that there was no recourse against this intrusion unless he did something that would harm someone in our family. Our neighbor built a house on the property that backs our small barn where our 2 minor-aged daughters house their 4-H animals. Shortly after he moved in, he placed 3 cameras in a line of trees about 5 feet off our property line, facing our property and pointing directly and deliberately towards our barn. He is able to view the cameras and see our children at the barn as well as possible audio. It was obvious these cameras were placed for the sole reason of surveillancing us. Our children's animals have never gotten out of their fenced area or barn, and our children have never gone onto his property either. We confronted our neighbor about the cameras, but he did not give us any assurance that they would be coming down. When we asked why, his response was because he could. My husband and I decided our best course of action was to block the cameras to see around the block with plywood and screen material. Our neighbor's response was moving the cameras to see around the blockage, forcing us to add more screening. We felt he was harassing us and our children, yet there was nothing we could do. We send our children to take care of their animals and we watch them closely. Last year, we did attempt to get a peace order served that would hopefully force our neighbor to take down the cameras that were intentionally placed to watch our property. Our neighbor successfully avoided being served the peace order, and we learned that even if he had been served, the judge had no authority under the current law to force him to remove the cameras. This bill would change that. In talking with others about our situation, I have been very surprised at the amount of people in our community that are also dealing with similar situations. These people also found they have no legal recourse. We understand that almost everyone has security cameras these days, and sometimes you may see a piece of a neighbor's property, but there's a clear difference between that and using the cameras for intentional surveillance. Our story is just one example why we support House Bill 236. Thank you.
Thank you very much. Are there questions?
Oh, come on, I gotta ask him something.
All right, the Vice Chair.
Okay, so thank you, Mr. Chair. Delegate Valentine, thank you for bringing this bill again. I just wanted to, you mentioned an expectation of privacy, or that they had an expectation of privacy in their yard. A person may have an expectation of privacy in their yard. Did you get a chance to research a little bit on what the courts have said about having expectation of privacy in your home and your yard?
I did not address that specifically, but I went all based on the residence definition to include your yard, grounds, outbuildings, common areas surrounding your residence.
And that you have an expectation of privacy.
Privacy in those areas as defined already in statute.
Great, thank you.
Delegate Carter.
Chair, just real quick. So if I had a outdoor, I have a small house with a small little yard. If I had a 8-foot fence around my backyard, do you think that I would have a reasonable expectation of privacy that people thought that they can't video surveil under, over my 8-foot walls of my little 12 by 12 backyard?
I think in that scenario that you would have a reasonable expectation that someone would not put a point of camera directly into your yard to monitor your activities.
Right, I would agree with you there. Now, let's just say that I lived out on a farm like your witness, who spoke very eloquently, by the way, and my backyard, instead of being 12 by 12, is 500 by 500. and I can't put up an 8-foot wall. But wouldn't I still have that same degree if my kids are playing or if I'm trying to do something that is on my own private property? Wouldn't I have some degree of expectation of privacy?
I think I would have some degree, but I think that the purpose of this bill is that it is a case-by-case basis, and the purpose would be in this situation would be to present the arguments you just brought should this be contested. And I think it allows a judicial officer to make that decision.
Right. So we're giving the courts the ability to look at a case where you've got kids who are trying to work with animals, and the expectation is that they don't really want, they're on their own personal property and they don't want other people watching them.
Correct.
So we want to give the courts the ability to say that they should have a reasonable expectation of privacy there.
Correct.
Okay. I think you've done a good job working on this over the interim.
Thank you, Mr. Chair. Delegate Valentine, what are the differences between this year's bill and last year's bill?
There are 3 specific differences. Actually, 2. One, the terminology the judiciary felt was somewhat broad, so we made it specific to an intentional act, not simply visual surveillance, but something that is done intentionally by an individual. And secondly, when we discussed with the judiciary, they felt they did not have the statutory authority in sections already in statute to order the removal, repositioning of cameras, as well as not only for this particular bill, but for items under the visual surveillance that are already in statute. So we added their ability to act on this in that particular section in order to provide relief to the petitioners.
Okay, thank you.
Thank you, Mr. Chairman. Thank you, Delegate, for coming in to testify. What is the meaning of intentional visual surveillance?
In my definition of this is, I am specifically set up a camera to specifically watch and intentionally watch you under a certain set of circumstances.
How do you know in this situation, we heard this last year, how do you know in this situation that the person intentionally was looking at the barn across the back versus looking at their 5 feet or 8 feet, and then the range of view included the barn?
Well, I think in the circumstance in this particular situation, as you see in the photographs, it's intentional for the area of the barn because as they put up partitions, the camera was moved and directed directly at the barn in the immediate area. So the individual is specifically angling a camera to see that particular area of the barn and area that the children are in.
Okay, so therefore, if the person had not moved the camera to include that range of view, it would not have been intentional, but because they did move the camera, so therefore they could see further, it is intentional.
I believe in this circumstance, they're moving shows that it's an intentional act.
Thank you very much.
Thank you, Chair. I kind of like where the delegate's going here. Is there a sequential act that could be added into some language here that helps prove the intentionality, that might help?
Well, again, I think we're going back to where we're just trying to get this particular situation before a judge if it does appear to be intentional. So, for example, as it's displayed in the photos, that there is that sequential act. You see, as you see in the photos, it starts at one level, they put a barrier up, it goes to another level, they put more barriers up, it goes to a third level. I think that's the sequential act that you're talking about.
Yep. Right. Thank you.
Seeing no further questions, that concludes the testimony for House Bill 236. Thank you to Ms. Leatherman for participating. That'll conclude the bill hearings for today. We'll have more bill hearings on Tuesday. However, the Judiciary Committee will be joining the Appropriations Committee in the great big new spectacular forum-like experience that is the joint hearing room at 2:30 today, 2:30. Where we'll be having a briefing on on the Department of Public Safety and Correctional Services. So we will see you at 2:30, and thank you all very much.